Hello friends. A lot has already been spoken about the Citizenship Amendment Act, NPR, NRC. All these are the current issues, and therefore I have prepared a set of questions to deal with the issues directly. I wish to share my legal perspectives with you without going into the politics, without going into any kind of controversy. We have to see what is the status of law and what is the legal perspective here. So some of the questions that I have prepared, I will read them out and we will try to solve these questions. The very first question: what are the advantages of becoming citizen? If there is so much of controversy regarding citizenship, then obviously this citizenship offers us some privileges, some rights. So what are the advantages of becoming citizen? Question number 2: what rights are available to non-citizens, legal immigrants as well as illegal immigrants, refugees? What rights are available to them even though they are not citizens of India? But does our constitution guarantee certain rights to them also? Do we have laws for the non-citizens also? Because obviously they all are persons, they are human beings, and we are obliged to observe the principles of human rights. The third question: what are the methods of acquiring citizenship? We will start answering this question first. The fourth question: what do we understand by overseas citizenship? And who is an OCI, that is Overseas Citizen of India? What are his rights? What are her rights? And what are the privileges? What rights are not available to them? And in what circumstances this OCI can be cancelled also? Because recently we saw some controversy regarding OCI cancellation also. Fifth question is: what is Indian policy of granting asylum to refugees? And who are refugees? So do we have a policy for granting asylum? How is asylum granted? What are the obligations of our country towards international law, international conventions? Have we signed any convention on refugees? Perhaps we have not. In fact, we have not signed any convention on refugees. So do we have our own policy of granting asylum? Because we have already granted asylum to the Tiptal refugees in the past. Sixth question is: what is NCR? And what is the Supreme Court's role in it? Sorry, NRC. What is NRC, National Register for Citizens? And what is the role of Supreme Court in this? We must be aware of this fact that the Supreme Court had earlier passed a judgment in this respect, and the NRC that was conducted in Assam was monitored by the Supreme Court of India. So we have to see that judgment and we have to see what the Supreme Court has explained about NRC. We will also explore whether the NRC rules have already been given or not. Seventh question: Supreme Court judgment on granting citizenship to the Chakma refugees from Bangladesh. We will also explore this judgment. The Supreme Court had itself ordered granting of citizenship to the Chakma refugees from Bangladesh. Can Rohingyas and other immigrants or refugees challenge the Citizenship Amendment Act? Can they challenge this? We will explore this answer also, because obviously this law, the Amendment Act, does not include them. But can they challenge this? Do they have the right to challenge under Article 14? What is the difference between immigrants and refugees? So we will have to understand that also. Question number 9 is: why didn't the Supreme Court grant stay on the enforcement of the Citizenship Amendment Act? We all know that recently this act was challenged in the Supreme Court of India, but the Supreme Court refused to grant stay. So obviously there must be some reason. There must be some interpretation by the Supreme Court as to why the stay was refused. Why shouldn't the stay be given in this case? Is Supreme Court justified in doing so? Is there any method? Is there any reason behind this? Question number 10. Why NPR? What is the difference between NPR and NRC? So why? What is the reason behind National Population Register? Why do we make it? It is not a new thing, obviously. It has happened in the past as well. Why the government needs to know the National Population Register? So can we challenge the NRC on the basis of Article 21? Many people have been contesting this NCR on the ground that it is violation of the procedure established by law. It is the violation of due process of law. But first of all, we will have to examine what is the due process of law, what is procedure established by law, and whether the conduct of NRC will be violative of Article 21 or not. The last question, CAA versus Assam Accord, right? Is there any real conflict between the Citizenship Amendment Act and the Assam Accord? What is Assam Accord? We will also see if there is a real conflict between Citizenship Amendment Act and the fundamental rights guaranteed to the citizens of India, especially the minorities, under Article 29 and 30. That is the fundamental right relating to culture, cultural rights. So the people of Assam have this fundamental right. The people of the Northeast also have this fundamental right. Let's see how they can be considered as minorities, because our constitution has recognized two types of minorities: religious minority and linguistic minority. So whether the fundamental rights of the people of Assam are going to be affected because of the Citizenship Amendment Act, and if yes, then there is a proper channel of challenging this. They can approach the Supreme Court. Article 13 read with Article 29 and 30, read with Article 32. So they can approach. There is no reason for violent protests. The Supreme Court of India is always there to come to the rescue of all those people who are being deprived of their fundamental rights by the state. We must, in the very beginning, accept the fact that the fundamental rights are not given to us by the state. We have that. And the state has the duty to guarantee these fundamental rights. And the state has the negative duty in the form of our fundamental rights, that is, they cannot take away these rights from us. They cannot deprive us of these rights. It means we were born with these fundamental rights. So these are 11 questions. Obviously, we won't be able to answer all these questions in the same lecture. So we will divide it in parts. Academic discussion. Therefore, first of all, we will see what are the methods of acquiring citizenship in India. Here we will be concerned with one of the methods so that we can see how the Citizenship Amendment Act has affected the 1955 Citizenship Act. So first of all, the 1955 Citizenship Act. We know that the Citizenship Amendment Act of 2019 has affected certain sections of the 1955 Act, like Section 6 has been affected, Section 2 has been affected, the third schedule has been affected, and Section 7D. So these are the sections that have been affected by this amendment. So first of all, we will see what is the original position. So I have this act here in the original PDF form Act, citizenship by naturalization. Right, there are 4 ways by which citizenship can be acquired in India. One is citizenship by birth, citizenship by descent, citizenship by registration, citizenship by naturalization. Later we will study citizenship by registration also, because we will have to apply that concept in case of Sri Lankan Tamils. But right now our concern is Section 6. Section 6, citizenship by naturalization, 1955 Act. It says that an application, where an application is made in the prescribed manner by any person of full age and capacity. So obviously full age, that is 18 years of age, and capacity includes the capacity to take decisions. So he must not be mentally retarded or a lunatic, not being an illegal migrant. So he should not be an illegal migrant. So who is an illegal migrant? A, those who have entered into the territory of India without valid documents. B, those who entered into Indian territory with valid documents, but they have overstayed. They were permitted to stay for a stipulated period of time, but they have overstayed. So if they overstay, they become illegal immigrants. So those who are illegal immigrants cannot apply for citizenship by naturalization. They are not eligible for this. If they are legal immigrants, now here what has the Citizenship Amendment Act done? Citizenship Amendment Act has affected the definition of illegal immigrants by making certain changes, some modifications. Now, according to the Amendment Act, the Buddhists, Sikhs, Jains, Christians, Hindus who came as illegal immigrants from Afghanistan, Pakistan and Bangladesh will not be considered as illegal immigrants. So the Parliament by law has taken away the stigma of illegality from these immigrants. So by law, now these immigrants will not be considered illegal. So the moment the law legalized their stay in India, they became eligible for applying for citizenship by naturalization under Section 6. So Section 6B has been added by the Citizenship Amendment Act. Now let us see what the third schedule says. The third schedule gives us the qualifications for citizenship by naturalization. Now here, we don't have to read the whole of the third schedule. Why? Because we are discussing Citizenship Amendment Act. So Citizenship Amendment Act has made some modification in the third schedule, C part. C part says that he has either resided in India or been in the service of government in India, or partly the one and partly the other, throughout the period of 12 months immediately preceding the date of application. So the first qualification that a person who is applying for citizenship by naturalization is 12 months. So this is the date of application. Let's say the date of application is 21st January 2019. Let's say we are taking a hypothetical example here. Now, 12-month period immediately preceding this. So this is 12-month period. He must be ordinarily resident during this 12-month period. So immediately before applying for citizenship by naturalization, he should have stayed in India and they should be ordinary residents. So ordinarily resident means that he has lived in India during that period, and very infrequently he might have traveled abroad. So infrequent traveling abroad will not mar his stay during this 12-month period, right? So ordinarily stayed in India during these 12 months, and then 14 years before this 12 month, right? So this is the period of 14 years. Before this 12-month period, take 14 years. He must have lived for 11 years. So during the period 14 years, he must have stayed in India for 11 years, and then 12 months immediately preceding. So overall his stay becomes 11 years plus 12 months is obviously 1 year, so 12 years. If he fulfills these conditions given in the third schedule, C and D taken together, then he will be eligible for applying for the citizenship by naturalization. Now, what has the Citizenship Amendment Act done? So let us see here what the Citizenship Amendment Act says. The Citizenship Amendment Act says in the third schedule, the following proviso shall be inserted. Provided that for the person belonging to Hindu, Sikh, Buddhist, Jain, Parsi or Christian community in Afghanistan, Bangladesh or Pakistan, the aggregate period of residence or service of government in India as required under the third schedule that we have just now read shall be read as not less than 5 years in place of 11 years. So for these people only, Hindus, Sikhs, Buddhists, Jains, Parsis and Christian communities coming to India, they will have to fulfill the period of 5 years only. So they should be ordinarily resident in India during this period of 5 years, plus this period of 12 months also has to be satisfied. So overall 6. If they fulfill this condition, so what has the Amendment Act done? the Amendment Act has not automatically granted citizenship to these immigrants. The Citizenship Act has, number one, taken away the stigma, the blemish of illegality, means they will not be considered as illegal immigrants. Plus, the period of 11 years given in the 1955 Act has been reduced to 5 years plus 12 years, plus 12 months before the date of application. So this is what has been done by the Citizenship Amendment Act. So you may say, the Citizenship Amendment Act does not have the intent of granting citizenship, but expediting the procedure of application for citizenship by naturalization. Let us see the Amendment Act in detail now. This Amendment Act begins with, this Act may be called the Citizenship Amendment Act 2019. It shall come into force on such date as the central government may by notification in the official gazette appoint. Section 2, the Citizenship Act 1955 has been modified. Any person belonging to Hindu, Sikh, Buddhist, Jain or Parsi or Christian community from Afghanistan, Bangladesh or Pakistan who entered into India on or before 31st of December 2014. So they entered into India before this date. So those who entered into India after this date are not going to get the benefit of this Act. Who will get the benefit of this Act? Those who entered into India before the 31st December 2014. Plus, if they have been exempted by the central government or under clause C or subsection 2, section 3 of the Passport Entry into India Act 1920, or from application of the provision of the Foreigners Act, or any rule or order made thereunder, shall not be treated as illegal migrant for the purposes of this Act. So what does the whole paragraph mean? The whole paragraph simply signifies, let us leave the technical details here. It simply signifies that all the immigrants mentioned here by name, Hindu, Sikh, Buddhist, Jain, Parsi or Christian community from Afghanistan, Bangladesh or Pakistan who entered into India as illegal immigrants on or before 31st December 2014. So this Act extends the privilege of expedited period of stay for making application for citizenship by naturalization. This Act has only given the privilege to them who entered before the 31st of December 2014, not to those who would enter later or who entered later. Section 3 of the Amendment Act talks about the changes made in Section 6A. So a 6B has been added. Section 4 of the Amendment Act talks about overseas citizens of India. So for that we will have to study overseas citizenship of India in the original Act of 1955, and then we will see what amendment has been done. So we will do it in parts. In this part, my only purpose was to explain the effects caused by the Citizenship Amendment Act. So we have seen the original Act, citizenship by naturalization, and we have now seen how the Citizenship Amendment Act has modified this. So the crux of the discussion is that only the period has been shortened. Instead of 11 years now, it is 5 plus 12-month period. This 12-month period has to be satisfied, and here 11 years will be read as 5 years. In our next lecture, we will see other questions answered. Like I have already given you 11 questions, I'll be answering each of these questions in the subsequent videos that are going to come. Thank you.